Good morning, one and all. I'm Dr. Veena. Here, we are going to discuss about intellectual property rights today. When we have seen complete shift from tangible to intangible, so whatever intangible, it has to be in the tangible form to seek protection. So to get a clear idea of it, as we have already seen that ideas are not being protected, once idea has been put into expression, that leads to a copyright, as it is envisaged under the Berne Convention as well as which have been already included under the TRIPS agreement. Now the next one, idea, innovation and invention. So for any creativity of that particular idea, if it is having any improvement or it has been coming or brought into existence for the first time as a creation, that can be protected as a patent under intellectual property right. Now coming forward to another idea, if an individual or a trader, anyone who have been creating an identity in the market in relation to the goods and which eventually denotes the quality of the goods. So for that manufacturer, that idea will be culminated into a trademark and that can be protected as long as the person who is using that in the market relating to that particular product. The idea, whenever we are talking about, this idea may give rise to various innovative things which can be even created, which can be very appealing to the eye, the products, where we look at for the designs of it. So here the designs which we are talking about is not of architectural designs of buildings, but which have been clearly with the products, could be the design of. It can be an example given here as a lamp design, flower vase, those things where it is clearly appealing to eye, which will be given as a design protection. So when we look at the idea again, which can be kept confidential, you can have your strategies in the market. So these ideas, those are considered as trade secrets. As long as it is kept a secret, that is being protected. Otherwise, it will, once it is in the open public, so there is no protection, it becomes everyone's the property. So here, very careful, and whether it is codified or not, it is under the common law where it has been protected in India. But when you look at some of the countries like US, which have been enacted the law codified to protect the trade secrets. Now, most important here when we look at it is the traditional knowledge which is coming from time immemorial, that is considered as a wealth of the nation, and this has been which have been the wealth of the nation, and the India has taken an initiative to come up with traditional knowledge digital library to protect our traditional knowledge, and out of which emerged as geographical indications, where the weather as well as the soil which gives importance to grow, just like Alfonso mango, which can be protected as a geographical indications, where the soil and the weather conditions literally help to grow such type of mangoes. So here, which have been naturally created, and as it is been given to the community who have been relying upon that as their livelihood. If you look at the Darjeeling tea, Assam tea, so as the geographical which can be categorized and grown, for that there is a geographical indications, and traditional knowledge gain a lot of importance when we look at it. So this gives us not to steal our knowledge and wealth by others to commercialize. So in such cases, traditional knowledge has also gained, and we are in the right moment to taking up that traditional knowledge digital library. Still it's been building, where they have been digitalized our knowledge, which is a treasure. So all these intellectual property rights can be just explained with one slide where it has been clearly displayed. A patent, here if you look at the ceiling fan, it has been clearly having the design and the motor or the engine which gives that functioning of it, where the functioning of that particular product is being invention for the first time, and that inventor will be eligible to get the patent. This will have an innovation. There is further improvements on that, even that is also will be eligible to get the patent. And as it has been having an aesthetic look, the creativity of an individual, where it can be displayed, even the lights and all those things, which differs from one fan to the ceiling, another fan, that design which is been very appealing to the consumers or to the individuals who would like to buy that product. So this will be even that design which has been unique and original, they also get the industrial design protection. So whether you take any of the product displayed here with respect to cell phones, here if you look at the cell phone, see we have seen this a drastic invention, the technology, where earlier it was only the telephones or the pages what we used to have. But now if you look at any of the cell phone which has got multi functions, where what all the earlier we used to carry a camera separately and a different message equipment separately, but here this cell phone with such a technology where it has been multi-functional aspects doing it, the calculator even it gives us. So where it has been clearly given these functions, it has been incorporated in one device that is considered as an invention, and this has got the standards when it been the improvements over the research and development when you look at from the telephone. So this improvement which has been a qualifying for the invention as a new will get the patent, as well how this appearance is and how compact it is. For that appearance, if it is unique, again it will qualify for the design protection. And at the same time, under what name the cell phone is being sold in the market, when we are looking at where there are n number of traders who have been selling such products. So to distinguish one manufacturer to another of these products, so the name which they have been using it, that name will create a brand in the market, either because of the quality of the product or because of the liking which has been unique design where the people have liked it. So in such cases, that manufacturer will get that edge over the others in the competition market. So for that reason, even that brand name or the logo which have been under which the product has been sold, that is being protected under the trademark. So that is Trademark Act of 1999 in India, which creates a goodwill in the market because of his innovations. When you look at the other type of intellectual property, as we have seen, is the geographical indication. When we said geographical indication, which signifies to that territorial place. So here if you look at in Andhra Pradesh, so even a Tirupati Laddu which has been already granted the geographical indication, so that has got that significance with respect to that place. So there are n number of examples pertaining to geographical indications. It could be Kolhapuri Chappal, it could be Alfonso Mangoes, Agra Peta, so Kondapalli Bommalu. There are several aspects if you go on, that is never ending list of it where it has been protected as a geographical indication. So this clearly gives us an understanding of each type of intellectual property. So there is in the competition market where the knowledge driven economy what we are talking about is definitely going to help across the globe to develop and to progress science and technology. In this way, there was a move forward made by India by bringing up a national IPR policy in the year 2016. So this national IPR policy 2016, which has the following objectives to create an creative India and innovative India. If you look at these objectives, the first one is IPR awareness, outreach and promotion. So as we have seen after the harmonization of laws as per TRIPS agreement across the globe under WTO, where it is to reach as there is a competition across the globe with respect to intangible properties. So how to outreach and the promotion of our IPR awareness. So first and foremost thing is this has to be brought, awareness has to be brought in the people, whether it is educational institution or any other R&D to compete with the other countries. And generation of IPRs, you have to identify that where all IPRs can be created. As we have seen 7 classes of the IPRs under the TRIPS, so we know how these has to be created. So elaborately we look into the another aspect of it. The third objective is legal and legislative framework. The legal and legislative framework for protection of each type of an IPR, we have separate legislations to protect, and there should be improvements to be brought in these legislative framework to protect and to compete with the countries. And administration and management is another objective. Commercialization of IPR. So when we are talking about commercialization of IPR, whole the concept of IPR is to reap benefits out of their creative innovation. So, commercialization is nothing but how to get a maximum profits out of their knowledge which have been created as an intangible property and traded in the world market. And another one, another objective when we look at it of this national IPR policy is enforcement and adjudication. So, having said that the intellectual property rights are protected, if any breach of that right, how these rights have to be protected and what is the mechanism which have been adopted either at the national level or at the international level, that has to be made clear and it has to be further looked into in the change scenario, what changes can be brought into to protect these IPR rights. And another important objective here is human capital development. So, when we are talking about human capital development, this is most important. All the universities, schools, R&D institutes, other institutes has to cooperate and at the same time develop the various, because those are considered as the sources of creativity. So, there should be a clear-cut nexus between the industries and the academia to develop this. The capital which we are talking about is human capital to capture the commercialization of IPR. So, these are the major objectives when we look at of the national IPR policy of 2016 in India. Now, as we said, in the one of the objectives of national IPR policy, that is most important when we look at how we'll outreach and promote our IPR. So, as you know all that various digital media and the social media, it has been clearly highlighted as PM Modi, our Prime Minister, the Modi has been given these the concepts where to develop in the digital India to reach with respect to IPR protection, Make in India, Digital India, Skill India, Innovative India and Creative India. All these are nothing but to promote and to outreach so that you can market your IPRs as a financial assets. So, these are most important when we look at under the Skill and Digital India, where the creativity has got a lot of scope. Now, ultimate objective of all the IPRs is with respect to commercialization, as we have told how from tangible to intangible and intangible to tangible property we have seen. So, the property when we are talking with respect to commercialization of IPR, the property here is denoted with the ownership as well as the possession of it. So, when we are talking about ownership, the commercialization by owner, if a person he himself is the owner of that property, whether it is tangible, intangible, but here in terms of intangible property IPR we are talking, it could be a patent, the patentee, the owner will be the trademark holder or the copyright holder, the design holder, how he can commercialize, and if at all that commercialization can be done with respect to commercialization by transfer. So, now the owner who is having the right, he can make use of it or he can by transfer commercialize it, these IPRs. So, commercialization when we are talking about it is pertaining to reaping the benefits in the market. So, this transfer can be done by various modes. So, transfer of property can be done by following modes, that is first by sale, by licensing and by assignment. So, as a owner, you can sell your intellectual property during the term of protection, as we have seen that it is only having an exclusive monopoly right, that means a limited period of right. So, within that period, the person, the owner who is considered as right to transfer his right by way of sale. And another one, keeping himself as a ownership rights, by licensing he can only permit to use during that protection where he can seek the royalties of out of that. So, by assignment is another mode of transfer of the property where he can reap the benefits even by assigning the property. So, as it is considered as a financial asset and property is an asset, so he has every right to transfer his property. Now, when these properties which have been completely transferred either by way of sale or by license or assignment, that is done through the contracts. So, as long as the contractual obligations we have, so if any breach of those contractual obligations, how to deal with it? between the parties, or the rights which have been protected, if it is been infringed by others who are no way related to it, but they are eating away the profits of as they did not have any permission to make use of it. So, under such circumstances, the dispute settlement mechanism at international level, WTO's dispute settlement mechanism is there, and at the same time under the TRIPS agreement, you have a settlement mechanism where that can be settled through alternative dispute resolution methods. But within the country, under the legislations, the various legislations which you have seen, in that you have every right to enforce your rights, which is also one of the objective of the national IPR policy. So, once the right is being given, that right has to be protected. So, that right, when it has to be protected, either through the courts of law or alternative dispute resolution methods. So, litigation is through courts of law, and the various forums which have been created, there the parties or the others who have infringed those rights, the owner can have the reliefs against those infringers. When it comes to ADR methods, there are various methods alternatively to decide and settle as they have been included, because they don't want to fall into the disadvantages of the litigation. Their market reputation is also equally important. In such cases, either they may go for ADR methods, which include, if you look at it, mediation, conciliation, negotiation and arbitration. These are the various methods by which they can resolve their IP disputes, so that they can reap and enjoy their rights which have been granted. Thank you all.